Welcome, everyone. It is good to see everyone here today on this beautiful fall Virginia day. So we're excited everybody's here. I also wanted to say how thankful we are to have our Zoom attendees here today. We've got a lot of feedback. Over the last 18 months, we've had to really embrace technology and up our game from a technology standpoint. This is the first group setting that we've had large scale Zoom meetings. So if there's any sort of hiccups, our Zoom audience, if anything is happening, if everything doesn't go according to plan, then I just want everybody, it's probably going to be Steve Clark's fault. So my longtime partner, our kid, Steve. But, when we go through the wealth management process, one of the things that we consistently see is the powerful impact that an estate plan has, a good, well-structured estate plan has on the families that we work with. So it's a big part of what we do. So we're excited about today. What we're going to do today is we're going to start with the basics of estate planning. Our goal is to have a series on estate planning. And as we continue, we'll get more specific, potentially more complex strategies from an estate planning process. But we thought this was a great first step to get a foundation and a base level knowledge of estate planning. We're so happy to have Molly McEvoy here today. We've worked with Molly for years, and we've always been impressed with the approach she takes working with clients. As I'm sure you can imagine, estate planning can be pretty intimidating. There are a lot of terms, a lot of things that we're just in day-to-day life, we're just not associated with. And Molly's always done a great job of explaining it in an easy to understand way. So Molly is with Armstrong, Bristow, and Farley and Schwarzschild here in town. She has practiced law. She focuses on estate and tax planning for individuals and families. She advises trustees. She advises beneficiaries in the administration of those trusts. Another important thing that Molly brings to the table, we think, and we like a lot, is that she's also a certified public accountant. So much of estate planning revolves around what current tax laws are. So her bringing that expertise to the table, we think, is a very, very powerful thing. So I did not mention at the beginning, my name's Sid Martin. I'm a managing director here with Heartwood, and it's time for me to exit the stage and welcome Molly. Welcome.
Thank you very much, Sid. And thank you all for being here. I echo Sid's sentiment that it is really nice to see faces, not on a screen, although it's great to have the ability to have screen connection with Zoom also, but it is really nice to be in a group setting. I know that I have not done a group setting probably in almost 2 years now, a year and a half to 2 years. So it is really nice to have you all here. With that said, I will also say that I didn't expect this great setup. So the Zooms that I've done have been like the one-on-one ones. So forgive me if I'm not so technologically savvy, but I think this setup should work. And if I forget to change the slide, I'll try to stay on top of that. So Sid they asked me to talk a little bit about basics of estate planning. And so I thought what would help is if I walked you all through essentially what I walk my clients through in an initial estate planning meeting. And so there are a lot of components to that. We've got taxes that everybody is really concerned about. And we'll talk a little bit about what's going on in the tax landscape right now. And then we've got the probate process, which is the court system. And those are two completely separate processes, yet they overlap. And we have to make sure that we navigate that process with clients as well as possible. And then, you've heard about probate, and then a lot of people want to know how to avoid probate and how do we do that? How do we get ourselves out of probate so we don't have to deal with that court system? So we'll talk a little bit about ways to do that. And then we'll talk about some other documents that we prepare as part of a basic estate plan that function during your lifetime that sort of fold into an estate plan and hopefully transition things a little bit easier. So to start off, I like to give my clients a little bit of a backdrop as to the taxes that we as estate planners think about. And there are 4 taxes that we talk about. We talk about income taxes that I'm sure everyone's familiar with. We talk about gift taxes. We talk about estate taxes, and we talk about generation skipping transfer tax. So to start with gift taxes, I'm going to talk about what the current law is. I don't know if you all have been reading the Wall Street Journal, paying attention to the news, but there has been a lot in some of the proposed legislation that would significantly change the laws that I'm going to talk about. But I'm going to talk about what the law currently is, what we know it to be, because I think that's really the only way we can plan it. Unfortunately, I don't have a crystal ball. The first type of tax that I'll talk about is the gift tax. And what is the gift tax? It is a tax that is imposed on lifetime transfers. So if you want to give your house to your child, if you want to give $1 million to your child, we have to report that on a gift tax return. And if necessary, depending on where you fall, if you've used your exemption, pay gift tax on that. Well, is every transfer taxed? No. Congress has decided that there is it's a $10 million gift tax exemption. It is indexed for inflation. So right now it is roughly 11.7 million. I just saw the new inflation numbers for 2022, and assuming that there is no change in the tax law, that will be roughly 12 million, just a little over 12 million that you can give during your lifetime to anyone free of gift tax. As noted in my little parenthetical, that law is scheduled to change as of the end of 2025. So it will revert back to a $5 million exemption, also indexed for inflation, which would get us up to a little over 6 million. So we're looking at right now 11.7, knowing that in 3 years it's going to drop to roughly 5 million indexed for inflation, about 6 million. So what happens if you make gifts in excess of that amount? Well, you have to pay a tax on that. And the tax rate is a pretty steep tax rate. It's a 40% tax rate. So that's that is kind of a steep number when you think about it. Give you a little bit of frame of reference though. When I started practicing, the estate and gift tax rate was 55%. So it was much higher, and income tax rates were significantly lower. Well, now we're looking at a state tax rate that's 40%, but our top income tax rate's over 40% if you add the net investment income tax. So again, that's why we as planners have to focus on that income tax too, to see what makes sense for gifting. Is every transfer taxed? No. Congress said, when they imposed the gift tax, that it really didn't make sense. People are going to give birthday gifts. They're going to give Christmas gifts. They're going to give holiday gifts. Should we tax all of that? No. So I'm sure that you all have heard of the annual exclusion gift, which again, it's another number that's indexed for inflation. But in 2021, you can make a gift of $15,000 to any person you choose without reporting it, without filing a gift tax return, without any kind of transfer tax implication. You can also pay this, and this is one of my favorites, actually, the annual exclusion gift, and then the second bullet point, educational and medical expenses, are one of my favorites because it has no transaction cost. If you want to make a gift to someone, you can pay their medical bills as long as you pay them directly to the provider. So if you pay it to the hospital, if you pay it to the doctor, however you want to do it, but if you pay it directly to the provider, it doesn't count against either your lifetime gift tax exemption or against your annual exclusion amount. Likewise, educational expenses, and this is one where I see a lot of grandparents pay for grandchildren's educations, and they will write a check to Collegiate, they'll write a check to St. Christopher's, St. Catherine's, and their kids don't have to pay it. It doesn't count against that annual exclusion amount. And it's really a huge benefit to everybody, right? The grandchild gets the education, the kids don't have to pay for it, and the grandparent is reducing his or her estate. So those are actually some of my favorites. I have one of my clients pays all of her family's medical expenses every year to the tune of she's got a big family, and it's about $200,000 a year that she is paying directly to the medical providers for children, grandchildren, everybody. And she is reducing her estate in a really tax efficient manner. You can also make gifts between spouses that don't use, assuming that the spouse is a US citizen, you don't use any of those exemption amounts. And of course, you've always got the charitable gifts, but of course, to make the charitable gifts and make them effective, and you've got to have the charitable inclination, which not all of my clients have that charitable inclination. The estate tax is sort of the second tax. So we've talked about gift tax. Estate tax is tied very closely with the gift tax. It is a tax that is imposed on transfers at death. So unlike the gift tax, which is lifetime transfers, estate tax is imposed on the value of your assets at your death. Like the gift tax exemption, we have $11.7 million of estate tax exemption, also indexed for inflation. It also is subject to that same sunset that the gift tax is subject to. And the current estate tax rate is 40%. So again, it's a pretty hefty tax. I was meeting with a client yesterday, and he has probably a $20 million estate. And we were talking about a family trust and a marital trust and his planning. And he goes, yeah, but I really think my wife has enough. What if I just give it all to my kids? And I said, well, that's fine. I said, but everything over, I said, for conversation purposes, everything over $11 million, you're going to pay 40% of tax to the government. Oh, well, I don't want to do that. And I was like, I didn't think you'd want to do that. You probably want to put it in a marital trust, defer the tax to a later date. But again, that 40%, as I said, some clients aren't very charitably inclined. He's like, I do not want to give 40% to the government sooner than I have to. And I said, I completely understand that. I realized I didn't have a slide for this. The generation skipping transfer tax is a tax that is imposed. It has the same exemption as the estate tax, estate and gift tax. The tax rate is also 40%, but the generation skipping transfer tax is a tax that's imposed when you skip a generation in your gifting. So if a grandparent wants to leave money directly to a grandchild, you can do that. But if you do it over the generation skipping transfer tax exemption amount, there is an additional tax. So it's in addition to the estate tax. It's called a generation skipping transfer tax. So again, people don't like to pay a tax that's unnecessary, but it is there. With regard to income taxes, the planning considerations. So we have people that want to make gifts, and they want to decide whether to make the gifts during their lifetime, at their death. When do I do it? How do I do it? What's the best way to do it? Well, one of the things that we have to think about is the income tax cost basis of those assets. We always say that one of the silver linings in death is that all of your assets, if they're included in your estate, I say all, not retirement plans, but most of your assets, if they're included in your estate at your death, get a step up in income tax cost basis. So what that means is that if you purchased, say you purchased your house for $200,000 and it's worth $600,000 at your death, the house is now, the income tax cost basis of your house is $600,000. So if your estate or your heirs go to sell the house and they sell it for $600,000, there is no capital gains tax paid. If you had kept the house during your lifetime and you sold it for $600,000, you would pay capital gains on the difference between the 600 and the 200. Now, that's notwithstanding that there are certain exemptions for primary residents, and I understand that, but for conversation purposes, there would be a capital gains if you sold it during your lifetime. There's not if it's sold after your death. So what happens if I wanted to give that house to my children? Well, if I give the house to my kids during my lifetime, they get what's called a carryover basis. So they would get my $200,000 income tax cost basis. So if they sold it, they would pay the capital gains on the difference between the 200 and the 600. If instead of giving my house to my children during my lifetime, I saved it and they inherited it at my death, then they get that $600,000 income tax cost basis and would incur no capital gains. So again, it's something that's really important to pay attention to. And especially in this climate where capital gains tax rates are most likely going up. I mean, I think consistently in the tax legislation that I've seen come out, or the proposed legislation that we've seen come out, capital gains tax rates seemingly are going north. Another way that we plan for lifetime gifts is with grantor trust planning. Like I said, I have that client who pays her children's medical expenses, and it's a great way to get money out of your estate. We have a lot of clients who plan with what's called a grantor trust. And what that means is that they can make a gift to a trust, and the gift in the trust is out of their estate for estate tax purposes, which that's great. We're going to use some of our lifetime gift tax exemption, fantastic. But an added bonus is when that trust is what's called a grantor trust, which means that the person who created the trust then pays income tax on any item of income that happens in that trust. And it's not treated as an additional gift to the trust. So they're paying additional tax, but they have the resources to do it. The assets in the trust can grow free of income tax. and everybody kind of benefits. It's a win-win. So that's something that we also talk about, because obviously you want your client to have enough money outside of the gift to be able to pay those taxes. We also structure those trusts in a way that we can, what we call, turn off the grantor trust status, which means that if the client decides that, ooh, that income tax bill is getting a little too hefty, we can take out the power that gives them that requires them to do that, and then the trust is kind of on its own. So that's something that we have been doing a lot with planning over the last 5 or 6 years. As the exemption goes up, we've put money into those grantor trusts, and then the client pays the tax on it, and the client's getting the tax money out of their estate. It's not a gift, and the actual gift is allowed to grow free of income taxes. Now that said, there was proposed legislation in probably mid-September that came out that changed all of that, changed all of the tax planning that we had been doing. And the proposed legislation essentially took our exemption that we know is going to sunset at the end of 2025. That was scheduled to sunset at the end of this year, so at the end of 2021. And all of that great grantor trust planning that we had been doing with clients, Congress sort of put a halt on and said, well, you can do it, but if you make a gift to a trust like that after the date of enactment, which, by the way, is whenever that gets through Congress and signed by the president, so there's no hard date, and we really didn't know what we were up against. That was all going to go away. If you make a gift to a grantor trust after that date, then we're going to pull that portion of the trust back into your estate, and you'll get a credit. And it was a it was a lot of complicated legislation. Actually, the legislation wasn't really complicated. The implication of the legislation was really complicated for us as planners. So we were kind of scrambling for a probably 6-8 week period. And then the next set of proposed legislation that came out about 2 weeks ago had none of that in it. So right now, we think that the estate tax exemption will continue to be the 11.7 million, indexed for inflation again next year to 12.2 million. So that's what we have to operate on. We unfortunately, I don't have a crystal ball. I guess the downside is, I was talking to somebody the other night about, okay, well, where do we stand? And I think that the downside for us as planners is that all of this legislation is now written. So it is on a shelf somewhere. And when there is a spending bill that comes up, and we've got all this spending that's going to happen, we now have on a shelf, okay, this will raise this much in revenue, this will raise this much in revenue. So it could all come back at any point in time. We just don't know. So what we are doing, or at least what I am doing for my clients, is planning on what I know the tax law to be, and making sure that my clients know that it's a sort of a minefield right now in terms of what's going to happen. But it doesn't look like there's going to be any change before the end of the year. But I hesitate to say that because we don't know. We just simply don't know. And I guess my goal as a planner is to make sure that you're informed of the risk if you choose to make one of those gifts before the end of the year. I think that's really kind of the most important thing. So that was probably a little too much on the tax side, but there's a lot that goes on in the backdrop of estate planning, that even if you don't have a taxable estate, the tax basis issues are impactful, because you may want to make a gift now or make a gift later or make a gift at your death. And the income tax piece really does affect even people who don't have estates that are impacted by the estate tax, at least at this point. So moving forward, probate. That was one of the things that, I think when I talked to Wes, he was like, people want to know how to avoid probate. And so when I sit down with clients and I ask them, I said, well, do you know what probate is? And most often they know that it's kind of going through the court system, but they don't really know what it is. And so I think what they mean is sort of the estate administration process. But technically what probate is when you take a document, and I can't say it's necessarily but when you take a document to the court in the jurisdiction where someone died and present it to the clerk. And then the clerk has to say, does it meet all of our statutory requirements? And if it does, then we record it. Really, probate itself is really just recording a will, is what it is. Now, what people like to avoid is all the stuff that comes with that, because usually when you probate a will, someone has to qualify as an executor, which is fine, but that's a lot of work. And when you have someone qualify as executor, then you sort of put yourself into the category of reporting requirements to the court. And that is done through reporting to a commissioner of accounts, which is an officer of the court. I will say, I think we're pretty lucky. We have really good commissioners of accounts in Chesterfield, City of Richmond, Henrico County. So it makes it a lot easier when you have reasonable people to deal with. But we do have some good commissioners of accounts. I will say that, sorry, I got to flip because I made a couple of notes here. We all think that it's pretty easy. You know, we have a standard procedure when we have clients come into our office to sign wills. And we have 2 witnesses and we have a notary and we have a self-proving affidavit, and we have a system down. COVID kind of threw us for a loop on that because Virginia does not have an electronic will statute. So you can't sign your will electronically. You may be able to buy a house electronically. You may be able to transfer millions of dollars electronically. You cannot sign a will electronically in Virginia. So we tried to get legislation through. It did not go through. There were some senators in the Virginia Senate that did not like it, did not want it. So we had to figure out during COVID, okay, what do we do? How can we strip out like having 6 people in a closed room in close quarters during a pandemic? And thankfully we did. We had some car side signings. So literally clients would pull up in their car and we would have our 2 witnesses who would stand 6 feet apart, and I would stand 6 feet apart, and the notary, and we would just swap the documents. And then we kind of stripped out as many signatures as we could. We had to get really creative, and fortunately we did. There were a couple where I did have clients come back and re-execute because I got a little nervous. But that was early on, and I think we ironed it out. But does it matter if a will is executed properly? It actually does. I had a client probably 5 or 6 years ago. Her husband died unexpectedly in a car accident. And she came in to meet with me about the estate administration, and she brings me this whole stack of documents. And I kind of bristled when I saw them because they had all the sign here, notarize, sign here. And I was like, okay, so they were sent to you for execution. Yes. Okay, was everybody together when you signed it? Well, no, I signed it, husband signed it. We just left it on the counter. The boys witnessed our signatures when they were home and walked through. And I was like, because I couldn't in good conscience tell the clerk's office that it was executed properly. Because one of the requirements in Virginia is that you have to have 2, if you're going to do the self-proving, 2 witnesses, you have to sign it in each other's presence, all together, all signing at the same time. So that's why kind of going back to presenting a document, I had to present that document to the court because it's not my determination to make that this was not a validly executed will. It's the clerk's office. So I presented it to the clerk and explained the circumstances around which it was signed, which of course they rejected it. And then we did have a prior will that we could submit to probate, but it's something to consider because I know people are like, well, do I really have to do that? Can't you just send me the documents? And I really try as much as I can to balk at that because it's really easy to mess up. So anyway, that was a really sad story also because her husband had unfriended her on Facebook. This is a little aside, had unfriended her on Facebook for whatever reason. And he was the keeper of all the family pictures, all on Facebook. And Facebook, unless you have language in your estate plan or have gone on and done the legacy, whatever, they wouldn't give her access to his account. So it was really unfortunate. I mean, we pleaded with them and they did not acquiesce, unfortunately. I will say there are also some statutory things if you do have to go through probate, and there's a small estate affidavit. So if the estate is worth 50,000, the probate estate is actually just assets passing, any asset that's in your sole name that passes through your estate. So if it doesn't have a beneficiary designation, if it doesn't pass by contract, if it doesn't pass by operation of law, anything. So if you have a bank account in your sole name, that goes through probate. If that asset or those assets together are worth less than $50,000, you can do what's called a small estate affidavit. You still have to probate the will. So you still have to record the will, but then you can fill out a small estate affidavit and you don't have to go through all of the rest of the administration process that goes with probate. You can also transfer a car without going through probate. Cars tend to be I'll just say the DMV tends to be a little difficult. So being able to do that without going through probate is actually kind of nice. But what are some other ways to avoid probate? Well, I guarantee you all have done some things planning to avoid probate without even knowing it. One is how your accounts are titled. So if you have an account that's titled as jointly with right of survivorship with someone, whether it's with a spouse or someone else, if you have, jointly with right of survivorship, whether it's with a spouse or someone else.
So this would apply to bank accounts?
Uh-huh. If you can title it jointly, or if you have a payable on death provision or a transfer on death provision, also with banks or bank accounts or financial accounts, that passes outside of probate. If you have beneficiary designations, so retirement plans that pass by beneficiary designation, those pass outside of probate. Life insurance where you have a beneficiary designation. Now, of course, you have to make sure those beneficiary designations are to the people that you want it to pass to. I actually had a conversation with somebody this morning about trying to deal with a beneficiary account that was payable to a first spouse, and first spouse was, collected the money. It was, the guy died, had a second wife with children, and first spouse was like, yeah, no dice. It's my name's on the account. The provider has to pay it to who's on the account. And so that was a little bit unfortunate. So beneficiary designations, and finally revocable trusts. And that kind of encompasses both the asset titling and the beneficiary designations, because if you have a revocable trust, and I always tell my clients this at the beginning of a meeting, when you sign your documents, we are not finished. And the devil is in the details, because you sign the documents, we have this great estate plan. And if none of your beneficiary designations and account titling matches up with your estate plan, you're going to go through probate and your assets may not go where you want them to go. And I say that especially with clients who have young kids and who say, oh my gosh, everything needs to be in trust until my kids are 40. Okay, that's great. But if you don't go back and change the beneficiary designation for your retirement account that has them, getting it outright, then we're not accomplishing your objectives. So people do think that when they sign the documents, they're finished, and they're really not. And they don't really like to hear that. I always try to remind them. But revocable trusts, so those are great vehicles to, and I'll flip the slide a little bit, but they can be the beneficiary of your assets at your death, so they're payable on death, or you can retitle assets during your lifetime. Now, is a revocable trust always necessary? So I don't think so. In a lot of cases, you may be just fine with the will, and you may still essentially be able to avoid probate because of those other means of transferring assets. But to give you a comparison, a will, if you probate the will, it becomes public record. So, that's kind of a disadvantage. And then you do have that ongoing reporting to a commissioner of accounts for the estate. In contrast to that, you've got a revocable trust where you get privacy. You've got a little bit more flexibility in the administration. It provides for asset management during your lifetime. And the assets are also more quickly available at death, which I do think is a big advantage of a revocable trust, because if you have to go through probate, you've got to qualify. Sometimes it takes a couple of weeks, maybe a month, to get a probate appointment. And nobody can transact on those accounts if you don't have somebody authorized to do so. So that would be an executor. Now, if you have those assets titled in the name of the revocable trust, you've got a trust document. Sid's got your trust document. He knows who the successor trustee is, and you die. The successor trustee can fill out the necessary paperwork, sign everything, and you can act really quickly. You don't have to wait for that court appointment. So I think that is an advantage to the revocable trust. But which do you use? And I think sometimes it depends whether if you have a pretty simple estate plan where you've got retirement assets and life insurance, and it's all going to your kids, and you don't have to worry about it, you may just be able to get away with a simple will. And if you have to probate it, if there are some assets out there that you discover later, fine, you can probate it and you've got it. More often than not, I use both a will and a revocable trust. And the will in that case is what we call a pour over will. And it's designed to capture any assets that haven't been titled in the name of the trust during your lifetime or don't have the appropriate beneficiary designation. But again, if you discover an asset later, you've got a will that you can probate, and then you can get and the will says, I leave, my tangibles to my spouse, otherwise to my kids. I leave everything else to my revocable trust. And then the revocable trust has all of the dispositive terms that we think of a will would have. And a lot of times when I say a will, in talking with clients, it's kind of this combination will revocable trust, because sometimes clients get confused with the revocable trust and what happens with that. But essentially, if we set up a revocable trust during someone's lifetime, what I encourage them to do, and I give funding language and beneficiary designation language, but I encourage them to retitle their assets in the name of the trust. And so that would be bank accounts, brokerage accounts, have life insurance payable to the trust. It sometimes will put houses in revocable trusts. Now, if it's a husband and wife, we don't necessarily need to put the house in the revocable trust during their lifetimes, because it typically passes to surviving spouse. At the death of the first spouse, that's when we like to get the deed to the revocable trust and put it into the revocable trust.
Discovered this recently, and if you don't have a revocable trust, you can actually do a transfer on death deed of trust for your house.
Correct, you
which
can.
I think it was a surprise to me. You cannot do it in every state, because I tried to do it for another family member, but in Virginia you can.
Yes,
So that's a huge element to avoid probate.
yes, you can do
And
the
then the DMV is better now, so they do have right of survivorship, and you can add a beneficiary in the car.
oh, you
So,
can.
yeah.
Okay.
That is brand new, because we just did it, and I was shocked, so we went in and did all.
Oh, that's really good to know, because I did not know that. We try to avoid that. And I never recommend that people put cars in their revocable trusts, because it's,
So you can do a car now, right of survivorship, and add a beneficiary.
oh, that's really interesting.
So,
Well, thank you for that. I
Yeah.
appreciate that. And the transfer on death deed, the one thing that if you do a transfer on death deed, which what that means is that automatically at your death, this deed, it's your ownership, you own it, but you're conveying it to a beneficiary that will happen immediately upon your death, which is great. There was a case out west where someone had done a transfer on death deed, and there was a catastrophic event to the house between when decedent died and when beneficiary got homeowners insurance for the house, and the decedent's homeowners policy wouldn't cover it. So if you choose to do a transfer on death deed, which I have several clients who have done it, I recommend that they let their homeowners insurance company know. And we've not had that problem with probate, because typically there's a provision in that contract that allows them to pay out during the period of estate administration. But that's just something to be cautious of. But the transfer on death deed is also a really effective way to avoid probate. So going back to the revocable trust, you can retitle assets during your lifetime. You've got the flexibility during your lifetime. The other thing that I like about the revocable trust is that if you have as the grantor and trustee, typically, folks serve as their own trustee during their lifetimes. If you are incapacitated, it allows for that transfer of management. I think it's more smooth with a trust than having to rely on a power of attorney. Not that power of attorneys don't work. I just find that they tend to have to go up the chain in the legal department at banks and other financial institutions, which can be a little bit of a headache. So if you have the trust in place and the financial advisor already has the trust, it makes that process a lot easier, I think. So that's a good segue into, does anybody have any questions, by the way? Feel free to ask.
How much does that trust cost over time?
What do you mean by cost over time?
Cost me, if I have a trust through you, what's it gonna cost me?
Well, if you set up a trust during your lifetime, it depends. That we bill by the hour based on time spent to draft the trust. And then once the trust is in place, if you don't make any changes to it, it's just as if you own the assets during your lifetime. So there's no ongoing cost there. It doesn't file a separate income tax return. It's essentially you during your lifetime. So that's a great question.
Will you repeat the questions that are asked so people on the-
Oh yeah, sorry. So the question was, how much does that trust cost? And after the initial setup costs, the drafting costs, the trust operates just like it's a grantor trust. So it operates just like the individual during his or her lifetime. So it doesn't have its own separate income tax filing requirement. It's really pretty simple. And so if you retitle your accounts, your 1099s are going to show up as, the Molly D. McEvoy Revocable Trust, and it reports under my social security number. So there's no additional reporting there. So it's really no additional tax cost there. As I said, it was the trust and having that continuity is sort of a good segue to the other documents that we prepare as a part of a basic estate plan. We prepare an advanced medical directive, which allows someone to it names an agent to make healthcare decisions if you are not able. In fact, I had somebody from Patient First call me the other day who said that someone had tried to use an advanced directive to get telehealth, but the person who created the advance directive was capable of making decisions. They just didn't want to do it. That's not when you can use an advanced medical directive. You actually have to be in, who knows, right? Especially telehealth, right? Like you don't even have to go anywhere. I didn't really understand it, but so I've started kind of hammering it home. I thought I made that clear to my clients, but my name was at the top of it. And he said, your client tried to do this. And he couldn't tell me who it was because of HIPAA, because I was like, really? I'm pretty sure that I tell people that. But in any event, if you can't make healthcare decisions on your behalf, if you are incapable of making an informed health decision, then your agent can make those decisions on your behalf. An advanced medical directive can say pretty much anything that you want it to say. It provides for organ donation. It provides for end of life instructions. I met with clients yesterday, and the wife was adamant. Give me 6 weeks. 6 weeks on life support and pull the plug. I don't care what else happens, 6 weeks. If I'm not back in 6 weeks, pull the plug. So it can say whatever you want. I did have one client, it wasn't a client of mine. I was just witnessing the signing for them for one of my partners. And the client wanted to be kept on life support until her kids were 18.
Oh my God. Oh.
Right? That's what I was thinking. I was like, are you sure you want to do that? But it wasn't my client, and I figured that ship had already sailed. But so you can put anything in it. I probably would not advise that. But anyway, that's what they did. And as I said, it also provides for organ donation. The one thing with regard to that as well is that if you do decide to be an organ donor, I also encourage my clients to double check their driver's license so that it's consistent. So that if you're an organ donor on your driver's license, it's less important that your advance directives say that. But if your advance directive says that you want to be an organ donor and your license says that you don't want to be an organ donor, you probably just want to reconcile those two. The durable power of attorney, it's durable, which means that it's effective once you sign it, and it names an agent to make financial decisions on your behalf. So if you're not able to, it allows somebody to take this financial power of attorney to the bank and say, I need to be added. I had to do this for my parents. I need to be added to my parents' account, and they would add me as a power of attorney. Now, that took about 2 weeks because I had to take it to the bank, and the bank had to make a copy of it, and they had to send it to their legal department, and they had to run it up the legal department and make sure that it said everything that I want to say. So again, that's one reason why I kind of like the trust, doing it by irrevocable trust. It's just a little bit easier to do that. But nonetheless, I think it's important to have the durable power of attorney just to capture any gaps there. The trust certification, if you do have a revocable trust, we prepare a trust certification that is in the Virginia code. You're allowed to give this trust certification to a financial advisor or to a bank. And that it says, I created this trust. This is my social security number. This is, these are the people who are authorized to act. It gives basically the information, the legal information that somebody would need to rely on to act on someone's direction. It's in lieu of giving. A lot of times financial advisors, you all request, you guys probably keep a lot of people's financial documents, but a lot of times the banks want the whole trust document. And one of the advantages to doing a trust, or one of the things that people like about doing a trust, is that it's private. Maybe I'm leaving assets in trust for one child because that child has a substance abuse problem, and I've outlined certain provisions in that trust that I really don't want everyone to see. So this trust certification is actually really helpful because it's signed, it's notarized, and financial institutions should be able to accept that in lieu of getting the whole trust document, which I think is really helpful. And lastly, we also do beneficiary designations so that when you go to retitle assets or change beneficiaries on retirement assets or things like that, you have the language that we know will work with your estate plan. One kind of aside to that is that the language that we typically provide doesn't fit in a box. So if you try to do those changes online, it doesn't always work. It's usually a C attached. And I've negotiated with people as to what parts of that can come out, like what's really important, or what can we truncate to make it fit and make it work. But it generally doesn't fit in a box. And that sometimes frustrates people. It frustrates the client, it frustrates the financial advisor, but we have the language the way we have it so that it works. A lot of times that happens if you have trusts for children that maybe end when they're 25 or 30. So it says, provided, however, if such and such child is, has not attained the age of 25, then pay it to the trust. And that's usually where people get a little frustrated with us as planners. But a lot of times I'll just do the see attached or attach this. And, people do appreciate that. Going back to the advanced medical directive, I knew I had written a note about it. It is not a DNR. A lot of clients come in to see us and say, I want a DNR, I want a do not resuscitate order. That is not something that we as lawyers can do. You need to talk to your doctor about that. So you need to do that with your physician. But sometimes people think that it is. It's a living will. It says pull the plug, but it's not a do not resuscitate order. Does anybody have any questions? That's sort of the basics of the estate planning piece. Is there any questions that we have? No?
Molly, the only thing that I'll mention that really resonated with me is the titling of accounts in the name of the trust. And that is a recurring theme that we see, particularly with new clients that are onboarding, that are coming to Heartwood, and we'll review client accounts. And we've already asked the client about any sort of trust work they've done or trust that they've established. And they are very proud of the fact that they've done that. And I'll read the trust, and it's a wonderfully written plan and a trust. But then we'll start to look at all of their account statements, and none of them are titled in the name of the trust. So Molly alluded to it in her comments, where she mentioned that really you haven't done anything at that point as far as executing on the overall plan and why you've even created the trust to begin with. So I just wanted to kind of re-emphasize if you do nothing else after this and you have established trust, I would go back, look at all of your accounts, bank accounts, financial institution accounts, and if you haven't already, get those in the name of the trust.
And in addition, go ahead.
Well, no, I have a question, and I think I may have missed this, but is the irrevocable trust usually done by an individual or by a couple, a spouse and their partner?
The question was whether the revocable trust is usually done by an individual or by a spouses. You can do a joint revocable trust. I have done one joint revocable trust. I find them really confusing, and I find them really cumbersome on the administration side. So when I do an estate plan for individuals, each spouse has his or her own revocable trust. Those plans mirror one another, so they're identical provisions. So at the death of both of them, if there are any ongoing trusts, those can be merged together. But I think that is much simpler from an administration standpoint than doing a joint trust. And actually, the only one that I did was because it would have been too hard to unwind it and the asset titling, and so I just tweaked it a little bit for that reason. But that's a really good question. In addition to what Sid was saying about making sure that you title your assets, which I think is really important, you also need to make sure that you title them in the name of the right trust. We have a situation right now where there are 5 accounts, person has died, 5 accounts at a financial institution. One is in the correct name of a trust, the name of the trust that exists. One is in the name of a trust that we don't know if it exists because no one has a copy of it, but the date is the same date as the trust that we know that exists, but it has a different name. 2 accounts are in the name of a trust that we didn't know about. And we didn't do the planning, by the way. Someone came to us to help with the administration. We did not do the planning. 2 are in the name of a trust that we have no idea what it is. The financial advisor doesn't have a copy of the trust. They don't have a trust certificate. They've got nothing. And then the last one actually had beneficiaries. So that was fine. So they're actually going to have to go to court because we don't have a trust. We can't do any kind of settlement because we don't know who to bring in to the mix as parties. Yes.
When it comes to estate planning, and of course we're getting up in age, so we probably have several different wills over the years. Is there any way to put them to bed so they don't raise their head up?
Well, when you execute a new will, it revokes your prior will. So it automatically, the question was, is there any way to put older wills to bed after you update your estate planning? When you sign a new will, it revokes the prior will. I always encourage my clients to physically destroy the prior will so that there is no ambiguity, just for the avoidance of any.
The most recent
Concern.
date, just like a DNR or an advanced medical directive is what's going to stand.
Correct. The most recent one.
Now, if you have a revocable trust, you have a will, and you've got several different vehicles that you've been putting in line, does the new will just wipe that all out?
The question was, does a new will wipe out any prior planning if you've done planning through a will and a revocable trust? And the answer is no. The will revokes the prior will. It doesn't do anything to the trust agreement. So if you amend your trust agreement, then you want to make sure that you're saying, that the document says, I hereby amend and restate, and you use the same date. So if you've got assets titled in the name of that trust, you've got a date out there consistent, and then the provisions of the trust change. But you do want to make sure that you clearly say, I revoke the terms of the trust. And typically we say that in the beginning, like I revoke articles, 1 through 12. And then right before the person signs it, it says, in all other respects, I, hereby amend and restate as above, the trust dated whatever the original date was, so that there is no ambiguity. Yes.
So to follow up on the naming of documents, we heard you say, or someone said, don't need to do that for couples if they're both still alive. You can transfer the real estate into the trust on the death of one of the spouses. Would that also be true for financial accounts?
Anything that's jointly titled, because you can't name a beneficiary. The question was, if you don't retitle assets in the name of a trust during someone's lifetime and one of the spouses a joint account, then at the death of the, is that true for real estate as well? Do you need to, or for financial accounts as well? I think that the answer is yes. You could title it jointly in the name of your revocable trusts. That's one option and you still get the creditor protection of tenants by the entirety. Or you could wait until one spouse dies and then retitle it. You can't name a beneficiary of an account. You can't pick one trust because we don't know who's going to pass away first. So you can't really name the beneficiary that way, but you have two options. One, you could put it in your revocable trusts, half in each or whatever your percentages are. And then, or you could just wait until the first spouse passes away. You don't have to go through probate, obviously, at that point, and then at the death of the first spouse, title it in the surviving spouse's revocable trust.
So if you have assets that are in individual names and it's been some individual spouse in, we can change those. We can add each other to the account, make them joint accounts. No gift issues there because of spouse, right?
Correct.
Or we can just have title totally.
Yes. So the question was, if you have an account in husband's name and wife has accounts in her name, can you add spouses without having any gift tax consequences or title them in the name of the revocable trust? And the answer is yes. You can add spouses. There's no gift tax consequence. There's no gift reporting. Or alternatively, you could title them each in the names of your revocable trusts. And really that impacts what the rest of your revocable trust says and where you want those assets to go at your death, whether you want them to pass to surviving spouse, or maybe there's some other place that you would want those assets to go. So as I said, beneficiary designations apply to retirement assets. And I guess the most recent, maybe not the most recent legislation, but recent legislation that I thought would be important to know. And I say recent, but this is probably pre-COVID, right? So it feels recent, but it's really not that recent in thinking about it. But the retirement assets used to be a really great way to plan and really defer taxes, at least defer income taxes. Because as you know, if you have traditional IRAs or 401ks, when you take those assets out of your plan per the required distributions, you pay income tax on those because we get to put them away free of income tax, pre-tax dollars, but we pay tax on them when they come back out. So as estate planners, that's where that beneficiary designation used to be great, because if you structure a trust correctly, if you structure the trust as a conduit trust, you could allow those retirement benefits to be payable to a trust for the benefit of kids and get the stretch payout over a kid's lifetime. So you've got the compounding effect of those assets growing, and then you're pulling out only like little bits of, if the children are 25, 26, you're just pulling out little bits over time. Well, at the beginning of 2020, I think, I could be wrong on the date, that rule changed, and Congress said no dice. Like that's been great, and you guys have been able to do that for a really long time, but we don't like it. And so that rule dramatically changed. So instead of having that stretch payout, in most cases, we are stuck with a 10-year payout. So all of those retirement benefits have to come out by the end of the 10th year. They don't have to come out ratably over that 10-year period. So it doesn't mean you have to take a 10th in the first year, a 10th in the second year, and ongoing. You could take all of it the first day, you could take all of it in year 5, but as long as everything's out by the end of year 10, you don't have the penalties that are imposed. I say sometimes a 5-year payout, because if you don't have a beneficiary designation and your assets are payable to your estate by default, then you're stuck with a 5-year payout. So it's a lot of income tax to pay over a 5-year period or all at one time. Now, are there exceptions to that? There are exceptions to that general rule. A surviving spouse can still take assets out over his or her life expectancy. And that's because typically spouses are within a relatively close period of age. And so we're not pushing it out forever. There are other categories here. I don't know if you can all see them: disabled individuals, chronically ill individuals. A minor child has until the age of majority, and then 10 years from that date. So that begs the question, is the age of majority 18? Is the age of majority 21? Is it 26 when parents can still pay your health insurance until you're 26? So I haven't had to deal with that, fortunately. And then if there's an individual beneficiary who's within 10 years of the decedent, then they can take it out over a longer period of time. But this really was a drastic change, because a lot of the trusts that we drafted for a very long period of time were what we call conduit trusts. And what that means is that any distribution that someone would take from a retirement plan would then have to be distributed out to the beneficiary of that trust, the primary beneficiary of that trust, in order to qualify for that stretch payout. And that's because you have to look at the age of the beneficiary. And I'm glossing over a lot of the details in this because it's really complicated, but essentially, if you structure the trust correctly, the trustee could take whatever that required distribution was, and if they paid it straight out to the beneficiary, then we got that stretch payout. And it was really a great deal. And so a lot of our trusts were structured that way. Well, if you have a client who is concerned about a child spending all of that money, and I'm saying that now my retirement plan that may be worth $2 million has to come out in a 10-year period, which, for simplicity's sake, let's say I'm taking out $200,000 a year, forgetting about growth and all of that. Well, that $200,000 has to go out to my beneficiary if it's a conduit trust. And people may not want that. I mean, it's really at that point, it's a control, taxes versus control. What's my cost benefit? So we have revisited that with a lot of clients who have really big retirement plans, just to make sure that that's what they really want. Because a lot of times the clients really want control to be at the trustee level rather than having money flow straight out to the beneficiary. So that's the oversimplification probably of the Secure Act. And then some other changes that you all probably already know about is that it raised the age for to begin required distributions to 72 from 70 and a half. And individuals who have earned income, even if they're past the 70 and a half, can still contribute to a traditional IRA. So it's to the extent of your earned income. And then it also, which is not related to retirement plans, but if you have 529 plans for children or grandchildren, you can use the 529 plans more broadly than you used to be able to. I think they could be used for secondary education as opposed to just higher education. So those were kind of some other highlights of that. But the biggest was really the lack of the stretch payout.
So I have a question about earned income. So if you're retired, but you earn, you can still populate an IRA?
Yes, and there are limitations. Yep, up to the limitations. Are there any other questions? Yes.
You have a situation where a couple of downsizes and one of the after subsequent to that time passed away. It sounds as though it would be a substantial tax that scenario. House is purchased for $200,000. Price raises, the sale of the house prior to the couple, the value of the house goes up to $1 million. And they'd be getting taxed on $800,000 of profit.
The question is about if a couple downsizes and they bought their house for $200,000 and then sell it for $1 million, what's the tax impact? And that's a good question. There is an exclusion for primary residence. And I believe it's $250,000 per person. So I think for the couple, they would be able to exclude $500,000 of that gain from capital gains tax. And you still report the sale on your income tax return, but there's that exclusion for that $500,000. And there's some limits as to how many times you can do it, and you have to have lived in the house. And there are certain kind of items that you have to check off to be able to exclude that $500,000. So it's not, you still do have, probably would have some capital gains, but it's not to the extent that you think that you would.
Are you still eligible to deduct the expenses associated with renovations and new systems and roofs and all that?
The question was whether you're still eligible to deduct all of the expenses associated with it. I believe you are. I would advise you to check with your tax preparer because although I do some of that, I always have to reread the rules when I do the income tax work. Yes.
When you were talking about trust certification, you mentioned financial advisors. Designate in the document who financial advisor is.
The question was with a trust certification, whether you need to designate who your financial advisor is in the trust certification. And you do not. It's really a document that you can give to your financial advisor instead of giving them a whole copy of the trust agreement. So it's sort of an and or. Some clients don't mind if their financial advisor has the whole trust agreement because usually the financial advisor knows the whole family circumstance and knows all the reasons that went into whatever's in there. So sometimes clients are fine giving the financial advisor the whole trust agreement, which has the information that the financial advisor needs to make any account changes. Other clients aren't as comfortable with that. And so in those cases, I recommend that they give the trust certification to the financial advisor in lieu of the whole document. But it's not specific to any one financial advisor. Yes.
Yes, I have a question around portability of assets
Mhm.
or the death of a spouse.
Yes.
I've heard there's some talk about changing the rules on that.
The question was about portability and whether there are any changes to that. So I'll back up by explaining what portability is. Portability is when a spouse passes away with assets that are less than the estate tax exemption amount. And you may have one spouse that has assets well in excess of the estate tax exemption amount. So what you are allowed to do now is file an estate tax return for if the less wealthy spouse is the first spouse to die, you can file an estate tax return for that spouse, and surviving spouse can claim whatever that unused estate tax exemption is. So if I died with $5 million of assets in my name, my husband could file an estate tax return and claim that up to the $11.7 million of estate tax exemption. So that $6.7 million of estate tax exemption would then pass to my husband and he could then use it. So he may be able to have his estate pass free of estate tax. The question is, have I heard anything about that changing? I have not heard anything about that changing, thankfully, because it used to be that we used to have to make sure that husbands and wives had assets equal to the estate tax exemption amount in each of their names, so that we didn't lose any exemption. And the portability has really made that a lot easier and saved a lot of transaction in terms of retitling assets between spouses, when you may not otherwise want to do that, because there's a great tax reason for doing it. But by the way, if you get divorced, you've now given your wife all of those assets. So
I have a question from online. How do you gift to the lifetime exclusion if you are limited to 15,000 annually?
well, the 15,000, that's a good question. The $15,000 annually means that you don't have to report it. If you want to make a gift more than $15,000, you can do it by a lot of different means. You can write a check, you can give a bank account, you can give assets, but you have a reporting requirement. And so if you're giving anything in excess of that $15,000, and it doesn't have to be up to the exemption amount, but if you give anything in excess of $15,000, you have to file a gift tax return for that year, reporting that gift. And that's the IRS's way of just keeping a running tally of what you've used of your exemption.
And if you do that, if you do exceed per individual, the 15,000, then let's just say you double it. Let's say it's 30,000 for an individual. So you file the gift tax, you file the tax return to reflect that. That additional 15 would just eat into whatever the lifetime extension is that you're passing, correct?
There's a nuance to that, but yes, if you are a single individual and you make a gift of $30,000 to someone, then yes, you've used $15,000 of your exemption. If you are married and you and your spouse decide to what's called gift split, and that means that your spouse has to sign off on that gift tax return, then essentially I've used my $15,000 annual exclusion, and I've used my husband's $15,000 exclusion as it relates to that donee, so the person who's receiving that asset. So in that case, you still have to file a gift tax return, but you haven't used any of your exemption amount.
Yeah.
Giving greater than 50, in this case, say you get 30, does that create tax liability for like children if you give them 30 instead of 15?
The question was, does it create tax liability if you give your child more than the exemption, the annual exclusion amount? And the answer is no. There's no tax liability to your child there. Yes.
And if only one spouse is alive at the time of the gift, there's no provision for posthumously taking another 15%.
Correct. The question was, if only one spouse is alive at the time of the gift, can you posthumously use the other spouse's annual exclusion? The answer is no. Both spouses have to be alive at the time of the gift. Any other questions? Yes. The question was whether there's a limit on the number of times you can make that $15,000 gift. You could do it once annually. And so I have a lot of clients who do it in January of every year, or do it at like Christmas time every year and December every year. So they try to do it at the same time every year so that they stay on their gifting pattern and track. Yes.
If you've got essentially a joint gift of say $30,000, is it possible that instead of saying, well, once one spouse is using their own plus the exemption from the other spouse, if they said, look, each of us is just giving 15, the check is for 30, but it's out of a joint account, and I feel I gave 15, and I think my wife thinks she gave 15. Are we okay?
The question is, if we give $30,000 out of a joint account and you both feel like you've given 15,000 from each of you, do you have to report that? The answer is it's sort of a gray area. I mean, I think you could reasonably take the position that no, you don't have to file a gift tax return. Sometimes when I have clients who aren't great at record keeping, I still prefer to file a gift tax return, because that kind of a gift tax return is pretty straightforward and not complicated and not expensive. And sometimes I feel like it's just better to have the paper trail, but it just, it depends. And it also depends, like if one spouse contributed to the account and the other spouse didn't contribute to the account, is it really a gift from both of them? so I think we need probably more facts to give a better answer. I think we're about wrapped up if there are no other questions, but thank you all for patiently listening.
Thank you, Molly, and yeah. And thanks for everyone participating. I know there are probably going to be follow-up questions. Just contact the relationship manager at Heartwood, and we'll answer every one of them. So everybody enjoy the rest of your day, and it's good seeing everyone. Thanks.